Hello? Hello? Welcome to JL. I'm Tally Rokos, and we're about to begin speeches for March 18th, 2023 reps. I just wanted to let everybody know a few things about what JAM is about. We are about the injustice in our court systems, all kinds of injustice, elder abuse, conservator guardianship, child protection matters, family court, and even criminal matters. We're here to bring out the injustice in our system and fight for those who need to be fought for. I'm getting started on a few things this month. One of the things that we've mentioned at our last meeting is the petitions to recall the corrupt judges. When I was printing off petitions today, I discovered I had run out of ink, so that's going to have to wait for another day. But things happen. When I was printing off those petitions, I decided that I don't think recalling them is going to be enough. I think we need a petition to have a criminal investigation. So I'm going to have my captains take that petition around also, and it will be on Facebook as well. So our first speaker today is Sabrina Dewey. Please welcome her.
Hi, everyone. Thank you for joining us. We, a small representation of the people, gather today in this historic building for one purpose. We are here today to unite and fight for our God-given rights, which led our beautiful nation's founding fathers to create a government not to give rights, only God can do that, not to allow rights, that is not their place. Our government was created to protect the rights we inherently have. Thomas Jefferson so beautifully stated on July 4th, 1776, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." We are gathered in grief, concern, and for some of us, fear. We unite in our grief over the children that have been taken, the families that have been ripped apart, and the gross abuse of power asserted on us by the judgment and poor decision-making of our government that's designed to protect us. John Jay in 1794 stated, "Justice is indiscriminately due to all, without regard to numbers, wealth, or rank. Yet thousands of parents, children, and families are denied basic justice and basic human rights to familial association." I'd like to talk a little bit about the Fourth Amendment of the United States Constitution. Section 1 states, "The right of the people to be secure in their home, in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." The 14th Amendment is similar. That states, "No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction equal protection of the laws." Not only does the U.S. Constitution care about our rights, but the United States Supreme Court has addressed this in several published opinions. In the case of L versus United States Immigrations and Customs from 2018, their opinion stated, "The interest of parents in the care, custody, and control of their children is perhaps the oldest of fundamental liberty interests." In Troxville v. Granville in 2000, they stated, "The Constitution protects the fundamental right of parents to make decisions concerning the care, custody, upbringing, management, and control of their children." In MLB versus SLJ in 1996, they stated, "The right to familial association is sheltered against the government's unwarranted usurpation, disregard, or disrespect." Duke University published an article called "Storming the Castle to Save the Children." Their conclusion, after studying multiple cases where removal of children had occurred, was that even though removing a child isn't beating them, removing a child is a form of violence. We've talked law, now let's talk science. In your brain, when your nerves send signals from whatever part of your body that there is perceived pain somewhere, the insula and anterior cingulate cortex are consistently activated. These are structures within the lower part of your prefrontal cortex. These regions are also responsible for social pain. When a small child is removed from their biological family, it is perceived in their extremely underdeveloped brain as an act of violence. Child protection, as defined by Minnesota's Department of Human Services on their website, states, Minnesota has various programs to help children who may not be in safe environments. County and tribal child protection workers work with families to prevent child maltreatment, or in some cases, work with the courts and law enforcement to remove children from the home if they are in harm's way. Child protection is a government agency. What is required to seize a person? Let's review the Fourth Amendment. The right of the people is to be secure in their persons, houses, papers, and effects. Against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched or persons or things to be seized. Seizure, as defined by Oxford's dictionary, is the action of capturing someone or something using force. Probable cause is constitutionally required to legally seize a child, or in DHS terms, remove them from the home. This is a seizure as they are taken into state custody, usually with law enforcement being their guise of permission. Under the United States Constitution, a 72-hour hold is illegal. Get a warrant. What is terrifying is that our government is not pursuing warrants. How many of you in this audience have had children, either your own or in loved ones' care, that have been removed by child protection? Please keep your hand raised if there was a warrant involved. No one. According to criminal law, kidnapping is the unlawful confinement of a person against their will, often including transportation. Minor children do not have the legal authority to consent, or bringing a child to the doctor or school or the dentist would be considered kidnapping. Who has the right and the authority for that transportation? The parent. Once again, the right of the people is to be secure in their persons, houses, papers, and effect against unreasonable searches and seizures. And as the 14th Amendment states, nor shall any state deprive any person of life, liberty, or property without due process of law. Due process as it relates to seizure of a person, whether to jail or state custody of any form, including child protection, involves a properly issued warrant. If a government agency is not obtaining warrants, they are not following due process, and this makes any and all seizures illegal. Yet this happens in our beautiful state every single day. Somehow, that's not all. Illegal seizures are not the end of the road for hundreds of Minnesota parents. According to state statutes, by day 311 of a CHIPS petition, which is Children in Need of Protected Services, which is foster care, the entire point of that is reunification, the agency is required by day 311 to submit a termination of parental rights petition if they feel they cannot return the child. For my case, this was done on day 311 at 7 o'clock at night. Some of the state statutes on how they justify that includes if a parent has written consent to terminate their own rights, called an involuntary termination, or if several different conditions exist, including refusing or neglecting to comply with duties imposed by the parent and child relationship, that a parent has been continued to contribute to the support of a child financially and has continuously failed to do so, that a parent is palpably unfit to be a party of the parent and child relationship because of a consistent pattern of specific conduct before the child or of specific conditions directly relating to the parent and child relationship, which are determined by the court to be basically unfixable for the foreseeable future. Or, following that child's placement out of the home, reasonable efforts have failed. It is presumed that reasonable efforts have failed if the child has resided out of the home for more than 12 months in the previous 22 months, if the court has approved the out-of-home placement plan required under statute 260C.212, and filed with the court, conditions leading to out-of-home placement have not been corrected. It is presumed that this is the case upon showing that the parent or parents have not substantially complied with the case plan given by the agency. Reasonable efforts also have to be made by the social services agency. There are also other statutes that address chemical dependency, if a child's been neglected in foster care, or if a child has experienced egregious harm in the parent's care, which is of a nature, duration, or chronicity that indicates a lack of regard for the child's well-being, such that a reasonable person would believe it is contrary to the best interest for that child or children, or any child or children, to be in the parent's care. If the parent has been convicted of specific crimes, that also constitutes. However, even with these different situations, subdivision 7 of this section of statutes states that the best interest of the child is paramount in any proceeding under this section. And where the best interest of the parent and child conflict, the child's interests are paramount. So we've talked a little bit about reasonable efforts. Reasonable efforts are slightly defined by Minnesota state statutes in 260.012. Once a child is alleged to be in need of child protective services, this is typically when a CHIPS case is initiated. The court shall ensure that the agency provides reasonable efforts to the family. These can involve different things such as therapy, classes, other forms of education. If a parent is struggling with income, maybe parents get a job, a vehicle, etc. There is no timeline listed in these statutes for providing services. Families on average wait over 3 months from the date that their children are removed from their home to even get a checklist of what the agency wants done to consider reunification and returning the children. Parents under Minnesota state statute can completely comply with every single aspect of a case plan and essentially be told in a court order, sorry, wasn't enough. Even after the guardian ad litem, social workers, and judge concur that the case plan was not only substantially completed under Minnesota state statutes, but was entirely completed. This happened to me. I and my 3 children are victims of child protective services in Isanti County. We are victims of judicial abuse. There were a total of 6 investigations into my family, 3 law enforcement and 3 child protection investigations. They deemed that some of my children had suffered child abuse, but they could never find a single perpetrator for any of the injuries, couldn't even provide a timeline for the vast majority of them. There was not one scrap of evidence as to who hurt my children. They did determine in 2020 that their dad was guilty of maltreatment. However, in that situation, no direct injury occurred to my daughter. They gave us a case plan in 2020. We completed it. They closed the case and walked away. In 2021, they returned due to a speculative report of potential abuse. This report also included concerns for medical neglect and possible marijuana use around the children. Neither of these concerns met anywhere near the state statute for what constitutes a concern, because the medical neglect was a concern that my 8-week-old daughter had not had her 2-month well child check. These are not required, these are suggested. These additional concerns, because they never came close, were screened out. The social worker who removed my children had been full-time staff with the agency for 3 days. I, to this day, have never been charged with anything more than a speeding ticket in 2018. I have never been found guilty of child abuse, child neglect, child endangerment. I have never been charged with the crime of those egregious acts, and I was quoted in the same court order terminating my parental rights as, quote, providing excellent care to the children, unquote. The court order also stated that I completed my case plan, my children were attached to me, and went as far as to specify that my youngest daughter, who was nursing at 8 weeks old when she was removed, had a strong and bonded attachment. They also stated that I had an attachment to my children and that I was engaged and involved in the children's care throughout the 18 months of the CHIPS case. I was never offered unsupervised visitation, never offered additional visitation, never offered any visitation expansion. The agency claimed they provided reasonable efforts, citing that they provided reasonable services. Criteria of what reasonable efforts includes: reunify the child with the parent or guardian from whom the child was removed, use of culturally appropriate and available services to meet the individualized needs of the child and child's family. My children were removed in March of 2021. By August of 2021, the case plan had been completed. The agency proceeded to not offer any additional services. They did not offer any additional visitation, and in fact, continuously took away visitation hours until February on day 311, when they finally decided to file a termination petition. I begged the agency for a safety plan and went as far as creating my own, which the agency refused to use. Seriously consider or expand on. They additionally refused to reach out to dozens of individuals that I have signed releases of information for during the investigation, which is required by state law that they consider all available and pertinent information, and throughout the case. I completed all services and initiated many additional services on my own. 2 social workers and 2 guardian ad litems testified under oath that there was nothing else I could have done to prevent a termination petition. Minnesota Statute 260C.301, Subdivision 1, Section 5, Number 3, conditions leading to the out-of-home placement have not been corrected. It is presumed that conditions leading to a child's out-of-home placement have not been corrected upon a showing that the parent has not substantially complied with the court orders and a reasonable case plan, and reasonable efforts have been made by the social services agency to reunify the family. Minnesota Statute 260.012, Subdivision D, Section 1. The agency has made reasonable efforts to prevent the placement of the child in foster care by working with the family to implement and develop a safety plan that is individualized to the needs of the child and child's family and may include support persons from the child's extended family, kin network, or community. Reading through the lines, I was set up to lose no matter what. My 2-year-old cried at the last visit where I was given 30 minutes to say goodbye to her and her 1-year-old sister. I want to go home. These comments were made during thousands of hours of supervised visits. The agency once stated in a court report it wasn't in the visitation notes, so we upped the documentation and ensured that it was. She wanted her mom. My 6-year-old, who was given a mere 30 minutes as well to say goodbye, sat in my arms for 20 of those minutes and sobbed as she had been informed by a social worker the day before of what was taking place. On the morning of December 2nd, 2022, I sobbed for hours as I packed up totes and bags and boxes of my children's belongings. I was given 30 minutes to say goodbye to each of my children by a therapist who has to this day been unable to provide any scientific-based evidence or any insight as to why 30 minutes was developmentally appropriate or even a good idea. My dog recently had puppies. Separating them from their mother at 30 minutes old, or 5 weeks, or 6 weeks is wrong, detrimental, and potentially illegal. We are treating children worse than dogs. Our laws and lack of oversight by departments such as the Board of Social Work and the Department of Health and Human Services allow this, and our children deserve better. I'd like to close with a quote. The state must declare the child to be the most precious treasure of the people. As long as the government is perceived as working for the benefit of the children, the people will happily endure almost any curtailment of liberty and almost any deprivation. Adolf Hitler.
Hello, and thank you everyone for being here today. I'm a grandparent of a now 19-year-old granddaughter. I was there for her birth, as was my son. We were a very active part of her life till she was approximately 1.5 years old. My son and Christina lived together, and for the first year, they raised Kayla in what I feel was a good, loving, nurturing environment. Things didn't go well, they split up, but my son, up until Kayla was 1.5 years, would watch her as